Good morning everyone! I'm Erin Dilan Arbolahan, the leader of Team Mga Kalikasan, and we're here to discuss the Republic Act of 9262 or the Anti-Violence Against Women and Their Children Act of 2004. So, let's start! So, what is the Republic Act of 9262 or the Anti-Violence Against Women and Their Children Act of 2004? This is the law that seeks to address the prevalence of violence against women and their children by their intimate partners, like their husband or ex-husband, live-in partner or former live-in partner, boyfriend or girlfriend or ex-girlfriend or ex-boyfriend, dating partner or their former dating partner. Now, here is Ms. Hernandez to discuss the next topic.
Thank you, Aaron. Hello everyone, my name is Sophia Angela M. Hernandez from BSN 1B. And also, I am the assistant leader of the group Makakalikasan. So my topic is, what is violence against women and their children under Republic Act 9262? It refers to any act or a series of acts committed by an intimate partner, such as the husband, ex-husband, live-in partner, boyfriend, fiancé, and who the woman had a sexually or dating relationship. And for that, let me state of this the against of woman. Against a woman who his wife or a former wife. Against a woman with whom the person has or had a sexual or dating relationship. Against a woman with whom he has a common child and the result of it is a physical, sexual, and psychological harm, and etc. The next topic will be discussed by Ms. Jumbel Miranda.
At this part of video, we will now tackle the acts of violence enclosed in RA 9262. The question is, what are the acts of violence which are covered under the RA 9262? We have the following: the physical violence, sexual violence, psychological violence, and the economic abuse. In physical violence, this is the act wherein it includes bodily or physical harm. It can be causing, threatening, or attempting to cause a physical harm to a woman or her child. It can also be placing the woman or a child in a fear of imminent physical harm. Sexual violence. This is basically the acts which are is sexual nature is committed against the woman or her child. It can be rape, sexual harassment, acts of lasciviousness, or treating a woman or her child as a sex object. It includes also forcing the wife and the mistress or the lover in a conjugal home wherein they sleep together in the same room together with their abuser, and by the use of force, causing or attempting to make a woman or her child to perform such sexual acts, and of course, prostituting the woman or her child. Psychological violence. This is basically the act of violence that is enclosed in emotional or mental condition of an individual, mainly woman or her child. Economic abuse. Acts that make or attempting to make the woman to be financially dependent upon her abuser. For instances and for the following, it includes preventing the woman to engage in any legitimate profession, occupation, and businesses. Controlling the woman's own money and property and destroying the household property. Controlling the woman's own money and property, and worse, destroying the household property.
Thank you, Jimbal. So good day everyone, my name is Jacinai Flores, and as part of Group Makalikasan, I am going to define the word children that is being used under the Republic Act 9262. So as defined under the Republic Act 7610, children refers to a person below 18 years of age or over but are unable to fully take care of themselves or protect themselves from abuse, neglect, cruelty, exploitation, or discrimination. It may be because of physical or mental disability or condition. As used in this act, it includes the biological children of the victim and other children under her care. Now, we have Mr. Between to discuss the next topic. Thank you.
Thank you, Justin. By the way, my name is Christian Janes Between, and I will define to you the dating relationship used under the RA 9262, or the Anti-Violence Against Women and Their Children Act of 2004. So, dating relationship is a circumstance in which the parties live as husband and wife without the advantage of marriage, or are romantically linked over a long period of time, or on a regular basis. For the next topic, Ms. Villaflor will discuss it.
Thank you, Christian. Good day, everyone. My name is Cristel Villaflor, and as part of Reforma Kalikasan, I'm going to define sexual relations as used under Public Act 9262. Sexual relations used under Public Act 9262 refers to a single sexual act which may or may not result in the bearing of a common child. Next is Ms. Yabut to discuss the next topic.
Republic Act 9262, the Anti-Violence Against Women and Their Children Act of 2004. The Battered Women Syndrome, as used under RA 9262. It refers to a scientifically defined pattern of psychological and behavioral symptoms found in battered women because of a long history of abuse. This acknowledges that women who have retaliated against their partner or who commit violence as a form of self-defense may have suffered from battered women syndrome, or the BWS. Any victim who suffers from BWS should be diagnosed by a psychiatric expert or a clinical psychologist. This will also help the victim in obtaining a just decision in her case. The law does not allow the offender to have custody of minor children. Their care is entrusted to the woman even if she is found to have BWS, or the Battered Women Syndrome. Additionally, Battered Women Syndrome, as a defense, victim survivors who are found by the courts to be suffering from Battered Women Syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements for justifying circumstances of self-defense under the revised penal code.
Thank you, Miss Kayla. And now I will tell to you who are the persons protected by RA 9262, or the Anti-Violence Against Women and Their Children Act of 2004. The persons who are protected by this law is the wife, former wife, a woman with whom the offender has or had sexual relationship with, a woman with whom the offender has a common child with, and the legislative or illegitimate child of the woman within or without the family abode. And now, what if the male partner complains about abuses committed by his wife or partner? He may file a complaint or case under the revised penal code, but according to ex-Senator Legarda, if we broaden the scope to include even the men, assuming they can all be abused by women or the supposes, then it would be not equalize the already difficult situation for women are not given equal opportunities, especially in the domestic environment where the macho Filipino man would always feel that he is stronger, more superior to the Filipino women. And for the next topic, Mr. T will discuss it.
Thank you, Christian. I am Chris Allen Bixbity, discussing about where should cases for violence against women and children should be filed, and is violence against women and children committed by men alone. Here are some fact cases may be filed in the regional trial court designated as family court of the place where the crime was committed. This court have original and exclusive jurisdiction over the cases. Furthermore, women can also be liable under the law. These are the lesbian partners, girlfriends, or former partners of the victim with whom she has or had the sexual or dating relationship. Ms. Villaflor is here again to discuss the next topic.
What can women and children do under Republic Act 9262? The offended party may initiate a criminal action or request for a protection order as an independent action or as incident in a civil or criminal action and other remedies according to legislation.
So I know a lot of you thinking about who may file a complaint under the Republic Act 9262. So the answer is it can be the punong barangay, barangay kagawad, or the counselor, the lawyer, the therapist, or the healthcare provider of the petitioner. Any or at least two concerned responsible citizens of the city or the municipality where the violence against women and their children occurred and who have personal knowledge of the offense committed. It can also be any citizen who has personal knowledge of the circumstances involving the commission of the crime may file complaint because violence against women and their children is considered as a public crime.
And now, let's talk about the penalties for committing violence against women and children. Offenders proven in court guilty in the crime shall be penalized with imprisonment ranging from 1 month and 1 day with 20 years, payment of 100,000 to 300,000, damages mandatory, psychological counseling, and psychiatric treatment.
What is the prescriptive for a complainant to file a complaint? The protection orders referred to in this section are the TPOs and the PPOs issued only by the courts. Section 24 Prescriptive Periods acts falling under Section 5 to 5 shall prescribe in 20 years. Endeavoring to compel or compelling the lady or her child to lock in, conduct with the lady of her child has the proper to cease or to cease from conduct which the woman or her child has the correct to lock in, or endeavoring to confine or confining the woman's of her child's flexibility of development. It conduct by drive or danger constraint, physical or other hurt, or danger of physical, or terrorizing coordinated against the lady of her child. This might incorporate but not restricted to the taking after acts committed with the reason or impact of controlling or limiting the woman's of her child's development or conduct, causing mental or emotional anguish, public ridicule, or the humiliation to the woman of her child, including but not limited to repeated verbal and emotional abuse, and denial of financial support or custody of minor children, or denial of access to the woman's child or children.
In this section, we will be discussing what is a protection order. A protection order is an order issued under this Act for the purpose of preventing further acts of violence against woman or her child, and the granting other relief as may be needed. The relief granted under a protection order serve the purpose of safeguarding with the victim from further harm, minimizing any disruption in the victim's daily life, and facilitating the opportunity and the ability of the victim to independently regain control of her life.
TPO or Temporary Protection Order is the order issued by the court on the filing of the application and shall be effective for 30 days. In BPO or Barangay Protection Order, the punong barangay is the one ordering the culprit to refrain from committing acts under Section 5A and Section 5B of RA 9262, and they shall be effective for 15 days. This can also be ordered by a fellow barangay kagawad if the punong barangay is not present. So, the protection order issued by the court after the notice and hearing of the victim is where PPO or the Permanent Protection Order takes place. This order shall be effective until the court nullifies or cancels the application of the person in whose it was issued.
Where can I apply for protection order? In the instances of temporary protection orders and permanent protection orders, petition for protection can be submitted with the appropriate regional trial court, family court, or municipal court, where the petitioner resides. In accordance with Section 409 of the Local Government Code of 1991, a barangay order can be sought in the barangay where the petitioner resides.
Who may file a petition for protection order? A protection order may be filed by the following: the offended party, the parents or guardians of the offended party, the descendants or collateral relatives of the fourth civil degree, officer or social workers of the DSWD, police officer who are in charge in woman or children case, punong barangay or barangay kagawad, and lastly, the lawyer, counselor, therapist, or health care.
How can I apply for a protection order? The application of the protection order must be in writing, signed and verified under oath by the applicant. A standard protection order application form, written in English with translation to the major languages, which is readily available, shall contain the following information: names and addresses of the petitioner and the respondent, descriptions of relationships between the petitioner and respondent, statement of the circumstances of abuse, description of the reliefs requested by the petitioner, request for counsel and reasons for such, and request for waiver of application fees until hearing, an attestation that there is no pending application for a protection order in another court.
So at this part, what can the woman do if the barangay official failed or refused to issue a BPO or the barangay protection order within 24 hours of the application? The BPO must be provided from the barangay official where the victim belongs within 24 hours from application. And if it's not, she can file an administrative complaint against the barangay official for not fulfilling his or her duty. The complaint must be filed with the sangguniang panglungsod or bayan. She can also go to the police station to complain against the perpetration. And she can go to the clerk of court or the clerk of court where she lives and request assistance in filing for a protection order.
So where can the protection order be enforced? But first, the provision of the protection order shall be enforced by the law enforcement agencies. The protection orders that may be issued under this act are the Barangay Protection Order or the BPO, the Temporary Protection Order or the TPO, and the Permanent Protection Order or the PPO. The Temporary Protection Order and the Permanent Protection Order are enforceable anywhere in the Philippines.
Can the barangay officials mediate or conciliate? The absolute answer for this is no. No, no. Ande, anya. Okay? It's not allowed to attempt to influence the woman to give up her legal action or the application for BPO, PPO, or PPO because it's like saying that violence against women and their children are a normal thing and it's happening every day, where in fact no one should be hurt by someone or anyone without enough reason. And now, we've reached the end of our report about the Republic Act of 9262 or the Anti-Violence Against Women and Their Children Act of 2004. Yay!
We hope that you learned something from us.